1689. Can you make that? That is one of our days, huh?
Yes, sir.
December 16 at what time?
9.
That's fine. That's all I have.
Here you go, ma'am.
25 CR 11085, Dominique Batty.
Yes.
That's all come in. There are two co-defendants with this one, Judge. I'm not sure.
I know Mr. Warren's been here. I don't know. There he is, right there.
Judge, the other.
I got a feeling Mr. Weekly's not going to be here today.
Right. He's not, and I think we probably need to set this for trial, but I don't want to do that until Mr. Weekly's here and we
I'm
know.
kind
That's
of
right.
interested for that. We're going to go to November.
Yes, sir.
What day of November, Judge?
How about the morning of the 25th? Can you do that?
Yes, sir.
Okay.
Yes, sir.
Mr. Warren, you have Mr. Tacker.
Correct, Judge.
Let's do that same thing.
Yes, Your Honor.
So they're going to give you a card. Ms. Coleman, they're going to give you a card as well. You know, Mr. Weekly had some surgery, so.
25 CR 11082, 25 CR 11083, 25 CR 11142, Marshall Benthel.
Judge, give up. Any more time?
Well, John, I want to tell you if I can take it. I got appointed in my prostate, and my doctor took me off, I didn't get to go. If I wanted to take and get my prostate, there won't be cancer now. I'm gonna believe I'll only get 18 years, but I won't keep my former cranks approved.
Yeah, when is your appointment, sir?
14th next month, and I can bring proof for you.
I'm fine. If you want to do that, Judge.
Why don't we do this in, let's go November 24.
And I'll bring proof.
You'll know what you can do with that.
And I'll bring proof.
That's fine. If you'll just bring a note from the doctor, that'd be great, sir.
Thank you.
You're welcome.
I didn't.
You're gonna have to undo?
Yes, Mr. McGill. I'm sorry, I'll try to.
That's okay. 25 CR 11144, Jeremy Boyd.
Good afternoon, Judge.
Mr. McGee?
Judge, I have been in contact with Mr. Hayes. I've got some discovery that I'm going to give Mr. Boyd a copy of today. Mr. Hayes contacted me this morning, told me that he had requested some body cam and stuff last week. Is that right, Andrew? And we're still in the process of getting the discovery.
30 days, 60 days, you tell me. 30 would be November 25, or December is December 16 at 9.
Judge, I can't do December 16, so I've already got something set the 24th at 1.
Very careful.
At
November.
Ray Treadwell.
That's okay, too.
You want to do that?
Yes, sir, if you do, I do.
Yes, sir.
I'll be here.
I'm sure you
wanna
will,
come?
Judge.
All right, November 24, 1, Mr. McGee.
Thank you.
Yes, sir.
Twenty-five CR 11161, Willie Hodge.
Your Honor, this is a plea agreement. It's a two-count indictment. Count one is a possession of Schedule II hydrocodone, in this case a Class A misdemeanor punishable up to 11 months and 29 days. Count two is a simple possession of Schedule VI marijuana, also a Class A misdemeanor punishable up to 11 months and 29 days. Your Honor, she's going to enter a guilty plea on count two, the marijuana. Receive a sentence of 11 months and 29 days, suspended to time served. Mandatory $250 fine, and she could be supervised by West State for the remainder of the term. Count one is going to be dismissed. Your Honor, if this case proceeded to trial, the state believes the proof would have shown that on January the 23rd, 2025, Agent Jeffrey Marshall with the West Tennessee Violent Crime and Drug Task Force conducted a traffic stop on a vehicle that Ms. Hodge was driving along with another individual here in Lake County, Tennessee. Based on a probable cause search, she found a couple of pills that later tested to be hydrocodone, as well as a green leafy substance that was identified as marijuana.
When she actually got pulled over, nobody else was in the car.
Ma'am, the clerk's going to place you under oath. If you raise your right hand for us, please.
You solemnly swear affirm testimony you're about to give is the truth, so help you God?
Ms. Hodge, I need to ask you some questions about your plea agreement with the state. You're obligated to answer my questions truthfully. If you were to answer any question falsely, you'd be punished for perjury. You know what perjury is, ma'am? You've heard the state tell me what the charges are that are pending against you in that two-count indictment there, as well as the potential punishment you would face if you were convicted of those charges, which, as I understand, would be up to 11 months and 29 days in the Lake County Jail in each instance. Did you hear and understand all that, ma'am? Yes, sir. As I understand, you're entering a plea of guilty to possessing marijuana, a misdemeanor possession of marijuana there. If you talk with Mr. McGill, you understand what the nature of that charge is, ma'am?
Yes, sir.
The state would be required to prove your guilt beyond a reasonable doubt at a trial in order to convict you of any criminal offense, ma'am. You have certain rights in connection with this case. Those rights include the right to the help of the lawyer at all stages of your case and on any appeal of your case. You have the right to continue with your not guilty plea and have a trial with a jury over these charges. At that trial, your lawyer would subpoena witnesses you thought would testify favorably, and he would cross-examine any witnesses who testified against you. You have the right to testify at your own trial, but could not be forced to do so if you chose not to. If you thought you weren't satisfied with the outcome of the trial or the sentence the court might impose, you have the right to appeal those issues to the Court of Criminal Appeals in Tennessee. Ma'am, do you understand those rights we have explained them to you?
Yes, sir.
You understand that by entering your guilty plea today, you're waiving or giving up each of those rights.
Yes, sir.
If you're convicted of any offense in the future, Ms. Hodge, this conviction might be used to increase your punishment at that time. And you heard the state review the facts of your involvement in this matter. Are those facts true, ma'am?
Yes, sir.
I understand you had some difference of opinion about whether there was somebody else in the car. That's okay. All right, but basically, did you possess marijuana? That's my question to you.
Yes, sir.
Okay. Are you voluntarily pleading guilty of your own free will and choice?
Yes, sir.
Has anybody promised you anything in exchange for your guilty plea other than the agreement on the sentence?
No, sir.
Has anybody threatened you or forced you to plead guilty? Are you under the influence of any drug or alcohol or medication today?
No, sir.
You've been able to talk with Mr. McGill about your case and about your plea.
Yes, sir.
As far as you know, has he done everything you need him to do to represent you? Do you have all the information that you need to make a decision to accept the state's offer today? You satisfied with what Mr. McGill has done for you in this matter?
Yes, sir.
We've got a document called plea of guilty and waiver of jury trial and appeal. You recognize that? I'm showing you the front page.
Yes, sir.
Now I'm gonna flip over to the back page. Is that your signature in the lower left-hand corner?
Yes, sir.
Did you read the document or have it explained to you
Yes, sir.
before you signed it? How you know what I'm gonna ask you? You answered me
But
before
I already
you
signed it, I read it all,
Okay.
I'm aware.
Oh, I'm just giving you a hard time, man. You understand you're gonna be on probation for the balance of your sentence, which is be 11 months and 28 days,
Yes,
right?
sir.
You're gonna report to the probation officer this afternoon, I think before you leave. there. If you were to violate the terms of your probation, you'd be right back here looking at me again, and we'd talk about what happened and what the consequences might be of that, okay? Do you have any other questions? Mr. McGill, anything?
No, Your Honor.
Plea of guilty appears to be knowingly, voluntarily, and understandably made. There's a factual basis for the plea. The court's going to approve and adopt the plea agreement. In case number 25 CR 11161 on the plea in count 2 to the possession, misdemeanor possession of Schedule 6 marijuana, the sentence imposed will be 11 months, 29 days in the Lake County Jail. That sentence will be suspended in time served. The defendant has 1 day jail credit. August 5, 2025 shall be on probation supervised by West State under the standard conditions for the balance of her sentence. Good luck to you, man.
Thank you, Judge.
CR 11107, 25 CR 11108, Leslie Manning.
Judge, that's Mr. McGill's. Maybe we could pass that matter. I think he wants to talk
We'll
to
come
us
back
about
to it, sure.
24 CR 10982, Tyler McClure.
Your Honor, this is an arraignment on a new probation violation.
Mr. McClure, you've been charged with violating the terms of your probation, sir. Are you going to be able to hire a lawyer to help you?
We represented him in lower court, Your Honor.
You did?
Yes, we
do
right now.
Are there other charges that give rise to the allegation of the violation?
Yes, sir.
Okay, court's going to go ahead and appoint a public defender to represent Mr. McClure then.
Judge, it's just a probation violation, but we'll await formal arraignment and enter a not guilty plea, and if we can have an appearance, because we might be able to work this out with the new charge as well.
Do we anticipate this is going to be at the November?
It's a criminal simulation that's set for an appearance right now. We can probably get it up there, do an information, so.
Let's do the arraignment date, just in case.
Set it.
Yes, sir.
Let's go November 17 at 1 o'clock then. That is the right day, isn't it?
Yes, sir.
Okay.
When are you setting your sessions? Thursday? Next Monday.
2 weeks. 2 weeks? No. 3 weeks.
20 CR 10702, William Singletary.
Your Honor, Mr. Singletary is here on a violation of probation. We have an agreement on this case.
This violation is based on a positive drug screen for methamphetamine. It's based on that, we have an agreement of a 90-day partial revocation, and he would extend probation for 1 additional year and return to the same terms and conditions.
Mr. Singletary, you have the right to have the court conduct a hearing to decide if you violated your probation, and if so, what the consequences would be. I've got this order, proposed order that says you're consenting to revocation, a partial revocation of 90 days, and to extend your probation for an additional year, then return to probation after the 90 days. It's also showing you have 29 days jail credit. Is that what you want to do in this case? Have you been able to talk with Mr. Armstrong, kind of weigh your options and make this decision? He answered all the questions you have about it. Anything?
No, Your Honor.
What's going to approve the agreement? Good luck to you, sir.
25 CR 11168, Danielle Stevens.
Your Honor, she's here for arraignment, but we represent Ms. Stevens in general sessions in Monterey County. You want to do?
Yeah.
Oh, okay.
Can we get my attorney?
Mr. Howell represents her.
Come on up to the podium.
I have Mr. McGee's in the hallway.
Mr. McGee,
Yes, Your Honor.
he's here. Let's see if we can find him.
Yes, Your Honor.
We'll just take care of it. Okay. Stay right there and see if we can
Yes, sir.
catch him quick.
He's busy man today.
Mr. Day, where'd you say you represent Ms. Stevens, in Dyer County?
In Dyersburg, pardon me, general session, Your Honor,
Okay.
municipal court, Mr. Howard in our office.
Okay.
represents her.
All right,
Actually, Commissioner, he represents me.
here he comes. He's coming in hot. Mr. McGee, Ms. Stevens indicates that you've been employed to represent.
I have been hired for city court in Dyersburg, Judge, but I told the individual that retained me that I would be here today to see what's going on in Lake County. There have been a lot of moving parts. I was gonna say, I know Mr. Hayes said that could I preliminary, without taking on, can I address, Your Honor, on perhaps getting a bond for Ms. Stevens
Bond.
today?
She has a bond.
Okay.
Your Honor,
Doesn't have one yesterday?
she failed to appear allegedly in July of this year. Your Honor issued a capias and set a $10,000 bond, but you did not revoke her underlying bond, because I think there might have been a call about, maybe she just gone to the hospital or something, I'm not sure. I don't think we
There
had
was
any-
something,
any
there was
proof.
something about that.
And
So
so
you still
you're-
have a bond, man.
I didn't know that I had a bond, sir, because when they checked the computer down there, they said I don't have no bond, sir. But,
Well, you're hearing it from the horse's mouth right now.
Okay.
You've
So I got a $10,000
So
bond?
that's an extra week
There.
you get out.
Mr. McGee, is it fair to ask you stand in for arraignment, just for arraignment
Just
only?
for arraignment purposes only, I wait for arraignment of the indictment. I know there's some information Ms. Stevens wants to give me about,
But can I speak real quick? I already served time on these charges last year and was sentenced on these charges last year, and that's why all the paperwork's all messed up and stuff, because
Sure does sound like it. That's why you need a lawyer. And I can't investigate it this afternoon, ma'am. I just
this
don't
is an
have the
arraignment, so you just
capacity
need to make,
to do
we
that.
just need to make your bond. And then
Okay.
we'll-
How much is the bond?
he just said it's a $10,000 bond, and so that Bill Bondsman, I'll talk with him.
Okay.
Judge, if you want to hold this to that 24th of November at 1 o'clock,
That's fine.
okay, just have,
Thank you.
I'll be talking to you.
Yes, ma'am. Thank you.
Thank you
Thanks
for
very
that,
much,
Judge.
Mr. McGee.
And I'm signing Mr. Swift's paperwork. Thanks, Andrew.
That's here, yes, yeah, yeah.
25 CR 11089, Keith Zeal.
Yeah.
Good afternoon, Your Honor.
Beg your pardon?
So good afternoon, Your Honor.
Good afternoon.
After speaking with Mr. Zeal and speaking with the state, I think we need to go and get a trial date in this matter.
Afternoon, sir. March 12th?
I can do the 12th if the state can do the 12th.
Yes, sir, that works for the state.
And there is no, Mr. Zeal does not have a red date. Reset.
What's the indicted charge?
Aggravated
Aggravated
assault.
assault.
Okay. I'm not inclined to do a pretrial conference on this unless you all think it's appropriate.
I don't really anticipate filing any motions, to be honest.
About you, Mr. Moore, anything?
No, not particularly, just maybe self-defense jury instruction or something like that, but I have to look more in the case, honestly.
Okay, I don't think we need a pretrial conference to do that. If you ask for it, I'll include it in the instruction packet, and we can, we'll figure out after the proof whether or not it's a
Yes, Your Honor.
appropriate instruction to give. Okay? All right, Mr. Ezel, we'll see you tomorrow. Thank you.
25 CR 11114, Michael Farrell Jr.,
There's actually two other code offenses also, Judge. So,
Mr. Clark is represented by Mr. Willis, whom I have not seen nor anybody from his
Judge,
side of the world.
I think Mr. Clark is actually set tomorrow, because Mr. Willis has a couple of cases tomorrow that got split up.
Mr. Reeves also.
Yeah, yes, please.
25 CR 11114, Zion Reeves.
For real, I'll read both of them.
Both.
Yes, sir, if that's okay with you. You, Mr. Farrell?
yes,
We're setting the trial date, is that what we're doing?
as far as I know, Judge.
Is this Mr. Reeves? Reeves?
Yes, Your Honor.
Good afternoon, sir. State asking for a trial date.
Yes, sir.
About April 29.
90 days out, it should be fine, Judge.
Yes, sir.
I'm open.
That works for the state.
Mr. Warren,
Yes, Your Honor.
does it work for you? I'm thinking with the, we're gonna try all three, the plan at this moment, try all three defendants.
Yes, sir.
That'd be 8:30, Judge.
Yeah. I think we probably ought to do a pre-trial conference. Let's do that March 23 at 1 o'clock. If that works okay for everybody. All right, and we'll catch up with the third defendant tomorrow. Okay? Thank you, sir. Thank you, Mr. Reed, Mr. Farrell, thank you.
CR 11107, 25 CR 11108, Leslie Madden.
Miss Manning is already set for a trial in the middle of January, but we're also going to do, in the interim, we're asking to do a mental evaluation. Or I did.
Which one is set? Is it the
One more.
vandalism indictment?
No, sir, the failure to appear.
Okay.
All three of them. I think that's what we said. Is that correct, Jim?
Yeah, it's 11107.
I don't think we need to reset that, do we?
Say maybe December, when
Just
we
check.
need to enter another order.
Okay.
December 16 at 9.
Last one, judges, call transcript, and then Mr.
What do you call it? I think he,
And then Mr. McGee back out.
Judge, while we have this moment, I have an order prepared for Mr. Terry, one day I approached. This is an order that he was evaluated by
Yeah.
Pathways,
Yes.
you know, and he's gonna make, Western
I
Pennsylvania.
got it.
Yes, sir.
I remember seeing the letter on
Yes, sir.
this.
And Judge, I don't remember when his next court date is off the top of my head, but obviously if he's there, we'll address that, but he's not on the trial docket.
He's not on.
No, sir.
I didn't think he was.
No, we had taken him off in this evaluation.
Yeah, I remember that. We're going to call Mr. Swift's case now.
25 CR 11171, Colton Swift.
You know, we have an agreement. Count one, this is a two-count indictment. Count one is possession of Schedule 6 marijuana over 1/2 ounce with the intent to sell or deliver a Class E felony. Range of punishment is 1 to 6 years, but as a range 1 offender, which Mr. Swift is, he would only face 1 to 2 if he went to trial and was convicted. Count 2 is possession of drug paraphernalia, a Class A misdemeanor, punishable up to 11 months and 29 days in jail. He is pleading guilty to count 1, the possession with intent, receiving a sentence of 2 years suspended to supervised probation through the Department of Corrections and a $2,000 fine, which is statutorily mandated. Count 2 will be dismissed. In this case gone to trial, the state police proof was shown that on February the 10th, 2025, Mr. Swift was pulled over by Highway Patrol, alleged that he was speeding in the 55-mile-per-hour zone on State Route 78. The trooper observed an odor of marijuana emitting from the vehicle and developed probable cause to search and found more than 1/2 ounce, approximately 29 ounces of marijuana.
Judge, we'll stipulate there's factual basis.
Thank you. Mr. Swift, we're going to place you under oath. Please show that you raise your right hand.
You solemnly swear affirm testimony you're about to give is the truth, so help you God?
Will you speak up just a little bit, because I hear you. I'm old and don't hear. So, Mr. Swift, been placed under oath because I need to ask you some questions about your plea agreement with the state. You're obligated to answer my questions truthfully. If you were to answer any question falsely, you could be punished for perjury. You know what perjury is, sir? That's making a false statement under oath on a material fact in court. That's what perjury is, and that's a crime in Tennessee. So you understand now why it's important to be truthful with me? How old are you, sir? 21 years old. Got a high school education? More than that, or just high school education? What do you do for work? In what? Okay. Are you gonna be able to keep your job? You've heard the state tell me what the indictment alleges, that is what you did, what you might have done there, as well as the range of punishment you could receive if you were convicted of that after a jury trial. Did you hear and understand all that? The state would be required to prove your guilt beyond a reasonable doubt at a trial in order to convict you of any criminal offense. I see from the papers that you're pleading guilty to possessing marijuana in an amount over 1/2 ounce. More like about an ounce is what it was, what it sounded like, or was it 29 ounces? 29 ounces. Sizable quantity of marijuana for a fellow your age and size. You know, that's a pretty good bit of marijuana there. You understand that that's a criminal offense in Tennessee. That's what the state would have to prove, that you possess marijuana in some quantity at all in order to convict you. You have certain rights in connection with this case, sir. You have the right to the help of a lawyer at all stages of your case and on any appeal of your case. If you weren't able to afford a lawyer and the court found that you qualified, the court would appoint an attorney to assist you there. You have the right to continue with your plea of not guilty and have a trial with the jury. At that trial, your lawyer would subpoena any witness that you thought was going to testify favorably to you, and he would cross-examine anybody who testified against you at the trial. You have the right, absolute right to testify at your own trial, but nobody could force you to do so if you decided not to. If you weren't satisfied with the way the trial came out, or the sentence the court might impose, you would have the right to appeal those issues to the Court of Criminal Appeals in Tennessee. Mr. Swift, do you understand those rights the way I've explained them, sir?
Yes, sir.
Do you understand that by entering your guilty plea today that you're waiving or giving up those rights as to these charges? If you're convicted of an offense in the future, they're going to use this conviction to increase your punishment at that time. You understand that, sir? You heard the state explain to me the facts of your involvement. Are those facts true, Mr. Swift?
Yes, sir.
Are you voluntarily pleading guilty of your own free will and choice? Has anybody promised you anything in exchange for your guilty plea other than the agreement on the sentence? Has anybody threatened you or forced you into pleading guilty? Not your mother? Are you under the influence of any drug, alcohol, or medication today, sir?
No, sir.
You've been able to talk with Mr. McGee about the case and about your plea.
Yes, sir.
Feel like you understand what you're doing today.
Yes, sir.
As far as you know, has Mr. McGee done everything that needed to be done to help you in this case?
Yes, sir.
You satisfied with his assistance?
Yes, sir.
I've got this document called plea of guilty and waiver of jury trial and appeal. You recognize that? Should have just seen that a little bit ago. That's the front side, and here's the back side. Is that your signature in the left-hand corner? Did you read the document or have Mr. McGee explain it to you before you sign it? Feel like you understand the content? Have any questions you want me to answer for you? You're gonna need to meet with the probation officer, probably gonna be waiting for, what? She's getting up right now. You'll need to see that lady before you leave the courthouse, okay? Anything else, Mr. McGee?
No, Your Honor.
Plea of guilty appears to be knowingly, voluntarily, and understandably made as a factual basis for the plea. The court's going to approve the plea agreement. Case number 25 CR 11171 on a plea of guilty, count one in possession with intent of Schedule 6 marijuana over a half an ounce. The sentence imposed will be 2 years with the Tennessee Department of Corrections. That sentence will be suspended at time served. A $2,000 fine is imposed. The defendant is a standard range 1 offender. He'll spend the sentence, probated sentence, supervised by the Department of Corrections under standard conditions. He has 4 days jail credit, February 10 through February 13, 2025. Good luck to you, sir. Hope not to see you in here again.
Thank you, Judge.
We haven't had on this doc, I'm sorry.
Judge, may I approach for 2 seconds?
Yes, sir. Yeah. I'll be down. Well, next time you see him, tell him I feel the same way. He's a good guy. He's a good guy. Every once in a while. That's purely by accident.
We call Mr. Robinson, this is an add-on to the docket, Mr. Thomas Robinson.
Thomas Robinson, okay.
There's 24 CR 11065.
Judge, he,
Yes, sir.
he failed to appear in September, and Your Honor issued a capias. Mr. Howie represented him, or still represents him. Mr. Howie showed me last week, he was actually in Pembina County Jail. I think Mr. Robinson has his paperwork, if Your Honor wants to see it, but I have seen it, he was in. The state's gonna ask to withdraw his capias.
After
If he's,
talking-
if he's satisfied with it, you know, it's not, it's rare that you get to,
Yes, sir.
that the state agrees with you on anything.
After speaking with with Mr. Howard's file, it looks like this is very close to resolution. If we could have the November, afternoon day, I think it's the 24th, or something like that, at 1 for probably a disposition. I know.
It is November 24, 1. Court's gonna withdraw the copies.
Good to go right now.
Good to go, sir. We'll see you next time.
We'll see you tomorrow morning, Your Honor.
Yes, sir, thank you. How about this one? That tag right there. Who was he? 25th?
At 9, going back to.
Yeah. Is it everybody else?
Yes, sir. Drummond's on last one.
Okay, well, we're gonna take about 5 minutes or so.
He's up here.
Okay, I'll move on then, why don't, where's Mr. Farmer?
Yes, 24 CR 11036, 23 CR 10945, Austin Drummond.
All right, what's our objective this afternoon? I know there's a motion pending by the state.
Yes, sir. The state would like that heard today, and then, as it relates to his two pending cases, 23 CR 10945, the state would ask to set that for trial. His other case, 24 CR 11036, he has a co-defendant, and Andre Brown, that is set, next month on November 24th at 1 o'clock, and has Mr. Weekly. The state wants to ultimately set that case for trial as well, but I think we probably need them together.
When did I set that? November 24 at 1, the co-defendant's case?
Yes, sir.
And let's set then 11036 for November 24 at 1 o'clock. And we're gonna, Mr. Farmer, are you opposed to setting the drug indictment for trial, sir?
No, Your Honor, we are not opposed.
One day?
Yes, sir.
What do you think, Mr. Farmer?
I would ask for 2 days, Your Honor. Because the court did set the other case for the 24th at 1 p.m.
November 24 at 1, yes, sir.
Yes, sir.
Does that work for you? I said it without asking you, I apologize.
Yes, sir, I do have matters in Madison County that morning, but I should be able to be here in the
Okay.
afternoon.
Okay. Thinking about April 30. That is a Thursday, I think. And it would give us a second day available if we had to have it.
Yes, sir, that works for the state.
Honestly, Your Honor, I have a child rape case scheduled that day.
May 7?
Your Honor, that would work.
May 7 works?
Yes, sir.
Yes, sir, works for the state as well.
Thank you. I think we probably need a pretrial conference. Mr. Farmer, April is, April 27 at 1 or April 28 at 9, whatever your preference is, for a pretrial conference, which is not going to take but just.
We would prefer the 27th at 1, Your Honor.
Okay. Is state's motion captioned for both cases?
Yes, sir.
Okay. Mr. Farmer, any opposition to going hearing that motion now?
Your Honor, Mr. Drummond has prepared a letter that the court, he would like the court to receive as an exhibit. Otherwise, I have no objection to hearing the state's motion today.
Seeing the letter?
I have not.
Okay. I won't, I can't decide on it until the state's had an opportunity to look at it, see what their position is.
You want me to get the other copy?
Judge, having read the letter, the state would still ask to go forward on this motion today.
Yeah, we're gonna go forward. Does the state have any objection to the court viewing the letter?
No, Your Honor.
May I approach, Your Honor?
Okay.
Your Honor, we just want that to be marked, made an exhibit to this hearing.
Well, I'll let the clerk, I'll tell you what we'll do, we will mark it as an exhibit, just for identification. Yes, ma'am. Do you want to make a statement before?
No opening statement or anything, Your Honor.
Your Honor, just very briefly, I'm happy to have this hearing and hear what the state's witnesses have to say and what the state has to say. I do think it's important to note and that the court could save itself a lot of time. If you look at the state's motion, the state's only legal authority is a statute, Tennessee Code annotated 4023-107, which is in the Title 40 and Chapter 23, which is a chapter of the Tennessee Code that is dealing exclusively with the execution of final judgments after the court has already imposed a sentence. And that is the very title of Chapter 23 of Title 40 is execution of judgments. The state is asking the court to take someone who is presumptively innocent and has not been convicted of a crime, is not serving a sentence, all of his prior sentences have expired. They want the court to take somebody who's not serving a sentence, who's a pretrial detainee, and take him to the Tennessee Department of Corrections and put him in prison. And the only legal authority for that proposition is a statute that doesn't apply to pretrial detainees. It's clear from the context of the statutory provisions cited by the state that it has nothing to do with this case. And we would cite I believe it's State versus Gray, which also supports our reading of the statute, that's 602 Southwest 2nd, 259. So, again, I'm happy to hear what they have to say and their accusations of how they say Mr. Drummond has been behaving in the Obion County Jail, but I mean, local sheriffs and local jails deal with allegedly misbehaving inmates every day in our state, in our country. And that has never been enough to send them straight to prison. I mean, they can charge him with a new crime if he committed a new crime while he's in jail. They can discipline him for violating their disciplinary rules. They can hold it against him in terms of sentencing credits and privileges. But you can't put a man in prison before he's been sentenced. And that is exactly what Mr. Drummond is. So the state's asking the court to do something we respectfully submit. The court does not have the authority to do it. And if that happens, the defendant will be asking for permission to file an interlocutory appeal. Thank you.
Yes, sir. Call your first witness.
Sheriff Carl Jackson.
All right, I'm sorry, I didn't see you. It's very confusing, sorry about that. I apologize.
And, Your Honor, we call for the rule.
The person's going to testify needs to wait out in the hall until you're called. Your witnesses in the courtroom on the tape.
Your Honor, the only other witness the state would intend to call is Sheriff Brian Avery.
Okay. That's your only other witness.
Yes, sir.
Okay, very good, everybody stay in there.
Sheriff Jackson, do you solemnly swear affirm testimony you're about to give is the truth to help you God?
Yes, sir. Wait, Jenny.
You state your name
Carl Jackson.
and you the sheriff of Obion County, Tennessee.
Yes, sir.
Sheriff Jackson, you also maintain the jail there.
Yes, sir.
And is Mr. Austin Drummond, the defendant, an inmate of your jail currently?
Yes, sir, he's pre-trial detainee.
Okay, and does he have charges in Obion County?
Not at this time.
And why are you holding him there?
I'm holding him for Sheriff Avery.
Okay. And how long has Mr. Drummond been in your custody?
I don't know I didn't write down the exact date.
Early August, sound right?
Yes, sir.
Okay. And where are you housing Mr. Drummond at within your jail?
We have a maximum security area, and he's being housed in that maximum security area.
Does he have any jail cellmates?
No, sir.
And since his incarceration in the Obion County Jail, has he been disruptive?
Objection, he calls for hearsay. Sheriff hasn't observed any of this.
You don't know that, he hasn't answered yet.
Objection be overruled, go ahead. As far as to me, he's not been disruptive.
Okay. And do you have reports of his behavior?
Objection, hearsay, Your Honor.
Just a minute. You're asking him if he has reports,
Yes, sir.
and the objection is hearsay, and I'll give you a chance to lay foundation for the reports.
Okay. Who monitors Mr. Drummond?
Well, I would have to say that all our correctional officers do.
Throughout different shifts?
Yes, sir.
Do you personally go back into the jail?
Not that often.
And have you observed anything of Mr. Drummond's behavior?
Mr. Drummond has never been disrespectful to me.
Okay. And if he was disrespectful or violated a rule, is there a procedure for your correctional officers to follow?
Yes.
Okay, and what is that?
Well, they would either be written up or sent to a D board.
Okay, and who presides over the D board?
That would be the jail administrator,
Okay, and who is that?
Captain Maynard.
All right. Do you have any involvement in the D board?
No, sir, I do not.
Okay. And so how would you be made aware of reports or any issues with an inmate?
Anything that comes to my attention would be made through Captain Maynard and reports. I mean, I can save the court some time, and be quite frank, if you want testimony that's not a hearsay testimony, Captain Maynard would be the better person.
I think that, let's let the general ask for that.
I'm sorry,
Is Captain Maynard here today?
he is here today.
Aaron, we gotta send a step out to him.
I think he has done so. He's not present in the courtroom at this
Your
time.
Honor, he stayed in when we called for the rules.
He did.
But he hasn't,
But
he hasn't heard any, I'm sorry.
Before we got to the heart of the testimony, he stepped out of the room. Court was observing.
So Sheriff Jackson, without getting into anything that is hearsay, based on what you have learned through your guards, do you have an opinion as to whether the Obion County Jail can safely maintain Mr. Drummond in your custody?
We have to this point. It causes a lot of undue burden and undue stress on our jail, and I realize that we are there to keep inmates, but if you can see, we have at least 6 officers here today for security. When we deal with him, we have 2 officers that deal with him consistently, wearing body cameras at all times.
And is it your opinion that he would be better off housed in the Department of Corrections?
It would be better off with my jail,
Yeah, that's what I'm asking.
absolutely.
Do you think you can maintain him?
Do I think that I can maintain him?
Yes, sir.
We have it to this point.
Do you anticipate being able to continue doing that?
I anticipate starting to lose correctional officers and having to replace correctional officers due to this particular inmate.
Thank you. I pass the witness.
Good afternoon, Sheriff.
Good afternoon, sir.
Just so I recap your testimony, you're concerned that you may lose personnel if you have to continue housing Mr. Drummond,
I am,
and you think it would be better off for the jail without him?
absolutely.
And it's an undue burden and stress for you to have to have so many officers come to court.
Yes, sir, it's costly.
And Mr. Drummond has never misbehaved in your presence?
Not in my presence, no, sir.
No further questions.
Redirect.
No, Your Honor.
Sheriff, you step out.
Thank you, Your Honor.
Call your next witness.
Captain Maynard?
You solemnly swear affirm the testimony you're about to give is the truth, so help you God?
Will you state your name?
Mitchell Maynard.
And Mr. Maynard, where do you work?
I work at the Obion County Jail, and just captain there.
Let's get him to spell his last name, please.
Yes, sir. Will you spell your last name?
Maynard.
Thank you.
Yes, sir.
And, Mr. Maynard, are you familiar with Austin Drummond?
Yes, sir.
How are you familiar with him?
He's one of the inmates that is in our facility.
Okay. And are you aware of some of his behavior since he's been in your facility?
Yes, sir, I am.
And how are you aware of his behavior?
Well, several ways. The first way would be write-ups, and also
Judge and hearsay,
How's it hearsay?
he's relying on write-ups to prove misbehavior, write-ups that I can't see or cross-examine.
not finished.
Okay. Why don't you lay a foundation for whether or not they keep those kinds of records in the course of their activities?
Yes, sir. Do you, Captain Maynard, will you describe the disciplinary process as it relates to any inmate, not just Mr. Drummond?
There's several different ways. It could be a write-up. Mainly any incident that occurs with an inmate is, I wouldn't necessarily write up, but documentation.
Okay, and how is it documented?
It is documented by the officer who was involved in that incident.
Okay, and do they have a duty to record that information?
Yes, they do.
Okay, and is it saved or preserved somewhere?
Correct.
And where is that?
It is in our system called ISOMS.
Okay, and they do this in the regular course of their activities as
Yes.
correctional officers?
Yes, sir.
Okay. And are you the individual that is the custodian of those records? In other words, you have access to them, you're tasked with reviewing them, keeping them, those types of things?
Yes, sir. I get those records daily.
Daily?
Yes.
And you go through them, you look at them, review them, those types of things?
Yes, sir.
Okay. And have you personally seen anything of Mr. Drummond, or do you rely strictly on those records?
I personally have had to deal with incident with Mr. Drummond, yes.
Okay, and what incident did you have to deal with on Mr. Drummond?
There was an incident with feces on the wall inside the cell and also the door.
Okay, and what day was that?
That day, I'd have to look here just a second.
Yes, sir.
And that would have been on the 30th of last month.
September?
Correct.
Can you describe that incident for us?
I was notified by staff, sergeant on the shift, about Mr. Drummond's had put feces on the cell door window, covered it. And at that time, Mr. Drummond's has, we've had several, I've spoke to Mr. Drummond's about covering the window of the cell many a times with paper. This time it was feces, and you cannot observe inside the cell with that window covered. So when I was notified about the feces covering the window, I've immediately set up some staff and basically moved him to a different cell, and of course had to clean that cell.
Okay, and what kind of issues does that pose for correctional staff if they can't see into the window?
That could be, for his safety and our safety.
What do you mean?
No visibility when we do checks. We do checks regularly, hourly. We have a system for that, and not being able to observe the inmate, through that and making sure he's safe. That would be an issue, and also for other officers, if having to deliver food or any kind of messages or anything to speak with the inmate or to interact with the inmate, it's a safety concern. If he, not being able to see what his position is.
And you said you had talked to Mr. Drummond about covering his door with other things?
Yes, Mr. Drummond's had wrote many letters and put on the door We've advised him not to cover his door window. You know, there's been incidents where Mr. Drummond has laid many letters on the floor. You know, covering the window is a rule we have there. It's, you know, it's a safety concern. So, yes.
Right. And what about letters on the floor?
Letters on the floor, I mean, you know, throwing other correctional officers off their job, trying to, I would say, mislead them into something that they need to be focused on, the inmate, not something else. A distraction, you could say.
Okay, and you, are you also aware of an incident with Suboxone?
Yes, I am.
Okay, and how are you aware of that?
We conducted a cell search, and while having Mr. Drummond checked, we conducted a strip search with, I had him split up and I had a strip search conducted when we immediately searched his cell, and it was on his person at that time.
And do you know how much was on this person?
Approximately around 39 strips of Suboxone.
Okay. Has he been criminally charged with that?
And not of yet, no, sir.
Have you had to take any disciplinary issues in the jail since he's been there with him?
With him, yes, sir.
What disciplinary measures have you taken?
As far as, you know, there's privileges we have taken away, you know, certain rec time, commissary. I'd be more detailed if I had that, but there has been some privileges taken away.
Has the removal of those privileges stopped or limited his behavior?
We are doing what the standard is, but we have limited, such as writing paper and that nature, kind of cut back on certain things so we can mainly get at a point where we can say, okay, you can start having this, you know. So we're working on that.
So have you gotten to that point?
No, sir.
Okay. And is it your opinion, can the Albine County jail handle Mr. Drummond?
No, sir. The staff we have, it's I mean, handle, yes, but as far as for a long period of time, I would say we would need a lot more help.
And is it a burden on the jail?
Yes, sir.
Is there anything else you'd like to tell us about?
No, sir.
All right, pass the witness.
Good afternoon, Captain Maynard.
Good afternoon.
You don't know where Mr. Drummond will go, do you, if he's moved out of your facility?
No, sir.
You can't tell the court or defense counsel whether it will be in East Tennessee or Middle Tennessee or West Tennessee, can you?
No, sir.
You can't tell the court or defense counsel whether Mr. Drummond's access to his counsel will be more or less than it is in the Albine County Jail, can you?
I can't tell you that, no, sir.
You can't speak for the Tennessee Department of Corrections, can you?
That's correct.
And so, if I understand you correctly on direct examination, you've had just one write-up?
No, as far as,
Mr. Drummond?
no, there's several incidents. I wouldn't say characterized as all write-ups, but informative. I would say documentation.
Okay. Well, how many actual disciplinary infractions has he received?
I would say more than 2 or 3.
And he's been there since the beginning of August?
Yes, yes, sir.
And which of these incidents would it be fair to say is the most serious?
I would say all of them.
Well,
Any incidents that occurs, it is serious.
So we talked about an incident involving feces.
Yes, sir.
How long was that, did that situation occur before it was cleaned up?
What do you mean? Can you rephrase that?
How long were the officers unable to see inside the cell as a result of the feces?
I would say maybe 10 to 15 minutes.
Okay. And none of the other occasions actually blocked visibility into the cell, the paper that you were talking about?
Yes.
They did block
Yes, sir.
visibility?
Yes, sir.
Well, how big were the pieces of paper?
I mean, different sizes. Anything that's in the window would cause a distraction to a correction staff.
Well, do you still have the paper?
Yes, sir.
Is it in court?
That I do not know, sir. I don't have it on me.
Isn't it true that was there a message associated with the feces?
Yeah, there was a message, yes, sir.
And what was the message?
I want to speak to my lawyer.
I want to speak to my lawyer?
Yes, sir.
What about the paper that you've been talking about? Did those have expressive messages on them as well?
I assume, yes, sir. I didn't read all of them.
But you can't say they didn't?
What's that?
You can't say they didn't have expressive messages on them either, can you? You can't talk about the contents of the paper that you don't have, correct?
Correct.
So, the incident with the Suboxone, that occurred in late September, early September, on September the 7th of this year, correct?
I believe so, if you have that paperwork.
And that's 2 months ago, correct?
Correct.
And nobody's charged Mr. Drummond with possession of contraband in your facility, correct?
Not yet, sir. No, sir.
And Mr. Drummond got to the O'Brien County Jail, I believe it was on August the 5th of this year, correct?
August 4th or 5th, something like that.
And it's fair to say that at the time that he arrived at your facility, there was a lot of public scrutiny on your facility at that time as a result of his presence, correct?
That I do not know, sir.
Well, you know that Mr. Drummond has always been someone who needed close scrutiny, correct?
Scrutiny as in what?
Tight security.
Yeah, I would, yes, sir.
He's always been segregated from other inmates since he arrived at your facility, correct?
Yes, sir.
He's not allowed to interact whatsoever with any of the other inmates, is he?
I wouldn't say allowed to interact, but he has interacted with other inmates.
Physically?
Physically as in what?
Well, has he been able to walk up and touch any of them?
No, sir.
So continuously since he arrived at your facility in early August of this year, he's had no ability to pass objects or receive other objects from another inmate, correct? If you've been watching him.
Correct.
And when you went in on September the 7th of 2025 to do this strip search, tell us how that works.
Well, that day, what happened was when we conducted the cell search, we immediately moved him to the strip search area, and he was strip searched by officers
Okay.
while his cell was searched.
Did you watch it?
The strip search?
Yes, sir.
No, sir.
Do you know, so you did not observe the strip search?
No, sir. I was conducting the cell search.
All right. So you can't testify whether or not this Suboxone was on his possession before he handed his clothes to the officers who were strip searching him?
All I can do is testify from the report from the officers who was given the Suboxones, and the Suboxones was given to me to put in evidence.
But you can't testify about the chain of custody of the Suboxone prior to that?
Yes, I can.
Well, okay. Where did it come from before it was
It
handed?
came from Mr. Austin Drummond to a
Where
correction.
where on Mr. Drummond?
From the report, it said from his hand. It was thrown in the floor for Mr. Drummond.
So how would Mr. Drummond have gotten Suboxone if he's been locked up in solitary confinement in your facility since August the 5th of 2025?
That's what I'm trying to find out.
You still haven't figured that out?
No, I have not, sir.
Is there a video recording of this strip search?
Not that I know of, sir.
So you don't record the,
We don't record doing strip searches.
well,
Have a camera in there. That's
well,
not,
have you recorded Mr. Drummond in his cell? Is there video that shows the inside of his cell?
from what incident, what,
Well, just while he's on an ordinary daily basis.
there should be, yes, sir. We have body cams, sir.
And when an inmate goes to do a strip search, do they pass through any kind of scanning machine first?
They do, sir.
Is there any report that the Suboxone was detected during that scan?
No, sir.
I believe when General Hayes asked you if you can handle Mr. Drummond, you said yes, did you not?
I wouldn't say, I would say handle as an inmate, yes, but, for a long period of time, no. My job is to keep him safe, and that's what I'm trying to do.
Thank you.
No redirect, Your Honor.
You step down, sir, thank you.
Sheriff Avery.
You solemnly swear affirm the testimony you're about to give is the truth, so help you God?
I do. State your name.
Brian Avery,
Will you spell it for the court reporter, please?
Brian, B-R-Y-A-N, Avery, A-V-E-R-Y.
And are you the sheriff of Lake County, Tennessee?
I am.
Is Mr. Drummond an inmate with you?
He is.
Okay, but he's not housed in your facility, is that right?
That's correct.
Where is he housed at?
Obion County Sheriff's Office.
And why do you not, have you ever had Mr. Drummond in your facility?
Not for an extended stay. He was processed in, and the day that after he was processed, he was sent to Obion County.
See, in his current incarceration, he has not stayed with Lake County.
No, sir.
And why is that?
Safety reasons. I don't feel like we're equipped to house Mr. Drummond,
And why do you not feel that way?
because it's our responsibility to keep Mr. Drummond safe, as well as staff, other inmates. And I have 2 pods over there where Mr. Drummond could be housed, and there's no way to lock inmates down in separate pods, keep them isolated. So I don't feel like that I could safely keep Mr. Drummond.
Okay, and are you worried about that just because the notoriety of his case?
Yes, sir.
Okay. And, you've been made aware by Obion County about the issues going on over there.
Yes, sir.
Does that change your opinion?
Not at all.
Do you have a large correctional staff?
I'm actually short right now.
How many correctional officers do you have on staff?
12, I believe.
Okay, and how many are you short?
3 or 4.
And, do you have a max facility to keep an inmate in?
Do not.
So if you had Mr. Drummond and he needed to be segregated, where would he go?
We have to go into population. We have holding cells, but holding cells are for short term, no more than 72 hours.
can only hold an inmate only 72 hours in those holding cells.
Okay. You're on right past the week.
Your Honor, I don't have any questions for the sheriff.
Thank you. You stood down, Jerry. Thank you, sir.
Thank you.
State would rest its proof.
Farmer, you want to call any witnesses, sir?
No witnesses, Your Honor.
Okay.
Just argument.
All right, I'll hear from you. Anybody got a copy of the statute? I tried to pull it up a moment ago and I was unsuccessful.
I just have a digital
Judge,
copy.
I've got the.
If you don't mind me reading it, can I read it real quick before you go?
Yes, sir.
I won't look at anything else on
Want me
your
to
computer.
walk up there now.
He doesn't want to come up here.
It's in chapter 23.
Just click, yeah, go ahead, pull it up for me if you will. Thanks, that's what we wanted to say. Thank you very much. I appreciate the courtesy. All right, Mr. Hayes.
Your Honor, the state would ask you to grant its motion and order the transfer of Mr. Drummond to the Department of Corrections pre-trial for safekeeping reasons. We did cite in our motion Tennessee Code Annotated 4023-107 that Your Honor has just read. And it states in subpart A, and the state thinks is relevant to its motion, in counties where, because of the insufficiency of the county jail, for any other cause, the court may be of the opinion that the safekeeping of the inmates may require it. The court may order the immediate removal of inmates to the penitentiary or to the nearest branch prison at the cost of the state before the expiration of the time allowed to remove the inmates. The state also did not cite to Tennessee Code Annotated 41-4-121, but would also point out in that statute, subpart A1, the sheriff has the authority when the jail of the county is insufficient for the safekeeping of a prisoner to convey the prisoner to the nearest sufficient jail in the state, or if the prisoner is a juvenile, to the nearest sufficient juvenile detention facility. The state would submit that the proof by Captain Maynard, Sheriff Jackson, and Sheriff Avery is that Mr. Drummond has been a disruptive inmate within the county jail of Obion County and has committed at least a new criminal offense, whether he's been charged or not, by possessing 39 Suboxone strips within the jail. That is at least a Class D felony for violating Tennessee Code Annotated 39-16-201 for possession of contraband. May also be another violation of 39-17-417, possessing with intent to sell or deliver 39 Suboxone strips. Captain Maynard has also testified about Mr. Drummond's behavior towards his jail cell. On one particular day, he covered his cell window with feces. Whether or not that was a message to the officers that he wanted to talk with his lawyers, it was still a hazard, as Captain Maynard has testified to. Does not allow correctional staff to complete their counts, to check on Mr. Drummond, those types of things. Same as when he has put paper over his window, put paper on the floor. These are safety issues, and the court would submit, or excuse me, the state would submit that TCA 4023-107 and 41-4-121 give this court the authority to send a pretrial detainee to the Department of Corrections. There's one other case, State versus Chapman, which is 977 Southwest 2nd, 122. Ms. Chapman was actually serving a misdemeanor sentence in West Tennessee, and because of I believe it was a pregnancy issue, was transferred to the Department of Corrections. And the Court of Criminal Appeals upheld that transfer even though she was only serving a misdemeanor sentence because of the safekeeping issues with a pregnant individual within a jail. Obviously, Mr. Drummond, or within a county jail, obviously he doesn't have those types of issues, but the state will submit to you that there is some authority to go ahead and transfer pretrial detainees to the Department of Corrections. There is safety issues. Mr. Drummond's behavior has demonstrated that, and we're asking your honor to grant the motion.
Mr. Foreman?
Thank you, Your Honor. I'll be as brief as I can. It should be pretty brief. The state filed this motion 2 weeks ago, and they only relied on 4023-107, to the best of my recollection. That second statute that's cited today was not even mentioned in the state's motion. I thought we were here, and the state's motion suggests that we were here to decide whether the court has authority and should exercise any such authority under 4023-107, which, as we argued, is about the execution of final judgments of sentence by the court, and the authority that the court has to expedite the process of transferring a convicted and sentenced defendant to the custody of the Tennessee Department of Corrections. Again, that is not a proper interpretation of that subsection of Section 107 of Chapter 23 of Title 40. This new statute that's cited for the first time today with the pregnancy language is talking about moving pretrial detainees from one county jail to another county jail. It's not talking about taking a presumptively innocent pretrial detainee and putting them in the custody of the Department of Corrections in a prison. Prisons are for people who have already been found guilty beyond a reasonable doubt or pleaded guilty and been given a final judgment and sentenced by a court. And one thing that stands out about the state's motion and the evidence today is we haven't heard one thing whatsoever from the Tennessee Department of Corrections. And none of them have come into this court to indicate where it is they're taking my client if they take him. They won't disclose the location that they're taking him to, and they won't tell you anything about whether I'm going to be able to see him, when I'm going to be able to see him, how far I'm going to have to drive to see him, how often I'm going to be able to talk to him, and
apparently from what he wrote on the window, he thinks that's a problem now.
it's correct. And there's been no assurances that if the court just turns over this presumptively innocent man to the Tennessee Department of Corrections before he's even had a trial in any of his many cases, there's no assurance that the access and communication are going to be any better than they are now. I realize and concede that the job of being a sheriff and running a jail is a difficult job, and I'm not here to argue otherwise. But that's what the statutes of Tennessee contemplate with respect to the office of the sheriff, that they assume that duty, and that's what the statutes charge them with doing. And they deal with misbehaving inmates every single day. And they can handle this. It may be, as they stated, it may be inconvenient, may be burdensome. But if that were enough to take misbehaving pretrial inmates and put them in the prison, then we'd have a lot of empty local jails across the state. And one thing I would also point out, Your Honor, is why is the state so eager to take him to the Tennessee Department of Correction as opposed to one of the other 95 counties in the state of Tennessee? There's 95 counties in the state of Tennessee, and there's several that are much closer to Lake County and Obion County than the secret location that TDOT is intending to take him to. And there's jails in Madison County, there's jails in Crockett County, there's jails in Gibson County, there's jails all across this region where if you believe their testimony that they're just incapable of handling Mr. Austin, he could be transferred. So for all of those reasons, Your Honor, we are not in a position, and we have tried to consider the state's request in good faith, by the way, but we're not in a position to agree to it, and we oppose it.
Thank you very much. Anything else for Hayes?
No, Your Honor.
Matter before the court on the state's motion to relocate Mr. Drummond's to the Tennessee, or to a Tennessee Department of Corrections facility due to heightened security risk, misbehavior, type issues there. It's clear from the testimony the defendant has created the need for heightened security and supervision. He is awaiting trial in case number 24 CR 11036. Actually, the trial has not been scheduled yet in that case, but has trial scheduled in 23 CR 10945 for May 7, which is approximately 7 months off. Mr. Drummond's behavior has created the problems for which he now demands law enforcement deal with and tolerate there. And what he's discovered is this is the way law enforcement deals with prisoners who have cases like this one. And Mr. Farmer, with all due respect, had not another case like this case. You know, very difficult to compare this to, as you say, any inmate who misbehaves there. The defendant, quite the audacity to create these problems and these situations and then criticize the correctional staff and the sheriff's desire to move him to a facility that's better geared to handle him. Court finds the defendant does pose a significant behavior and security risk, and his transfer to the Department of Corrections is authorized by statute and appears wholly appropriate in this case. The location of a defendant's detention, whether it is in any of the jails you mentioned, Mr. Farmer, or the Department of Corrections, has absolutely no effect or bearing on the presumption of innocence in this case. It may be bad for publicity, but it has absolutely no effect on the legal procedure and the process in this case. So the defendant is, the state is authorized to move the defendant to the Department of Corrections. The state will inform defendant's counsel within 14 days as to the location of Mr. Drummond's. Will monitor each 30 days and advise defense counsel as to any relocation by Mr. Drummond's, because I think it's a contrived position to take, but there's not going to be some secret location for Mr. Drummond's, and the court's not aware that the Department of Corrections or any other law enforcement agency in Tennessee, for that matter, practices that kind of work. Any other? Will the state prepare the order, please?
Yes, sir.
Anything else this afternoon?
No, Your Honor.
No, Your Honor.
Okay, we've got our reset date on the on 11036, and we've got our trial date on the other case.
Yes, sir. We expect him to be back in court November 17th for his new indictment as well.
Yeah. Arraignments, Mr. Farmer, and I think that's probably not within the scope of your responsibilities at this time, but Mr. Huffman, arraignments, as you know, November 17th, 1 o'clock.
Yes, Your Honor.
We expect Mr. Drummond's here at that time. If not, then he can go back.
Yes, sir.
What else?
That would be all, Your Honor.
Okay, all right. Anything else on the docket?
Yes, sir.
All right. We'll stand adjourned. One of each?
Signature, yeah.
I went to school with Compton's parents. Good day. Good, good. Thank you. I hope
He seemed like
his mama was to death.
Oh, that's what I said.
Yeah, I had my eye on his mama. Make sure it was all right.
Yes, sir, H-A-Y-S.
relation to Judge.
No, we spell our names differently.
H-A-Y.
Yes.